Hello, and welcome to the R. Matt Dawson Lecture Series. We're so pleased you could join us today, and we're of course especially pleased to have as our guest lecturer, Richard Susskind. I'm Liz Fraley. I'll be your moderator for today's lecture series, and a couple of housekeeping matters for you. First, if you have questions for Professor Susskind, we will have some time at the end where we can have a nice discussion with him. So if you will put your questions in the chat feature, I'll try to vet those questions so we can get to as many as time permits. Also, if you wish to claim continuing legal education credit for this, you'll receive an email following the lecture series that will have the details for how you can claim that credit. Before we get to Professor Susskind, let me turn this series over to our Dean, Brad Tobin, to give you some background about the R. Matt Dawson Lecture Series. Dean Tobin.
Thank you, Professor Fraley. And again, welcome to our event today as we present this edition of the R. Matt Dawson Endowed Lecture Series featuring Richard Susskind, internationally recognized author and commentator on the professions, and very notably, the legal profession. The R. Matt Dawson Endowed Lecture Series was established in 1995 by Joe Jamail and Jim Kronzer. You may be aware that Mr. Jamail was an absolute giant in the trial bar, and Mr. Kronzer was a lion in the appellate bar. Mad Dog Dawson graduated from Baylor Law School in 1938, and he went on to become one of the early shining lights in the trial bar of Texas. After a decade or so, he was on top of everyone's list of greats in the trial bar. We were blessed in 1971 when Matt interrupted a very successful high-profile trial practice to take over our iconic practice court program, an immersive program in the third year of our students' course of study, which presents them with 6 months of working exclusively with the rules of evidence, procedure, and specific courtroom skills. Matt excelled as a teacher, as a taskmaster in the practice court program. In 1983, he went back into the practice and he continued to have a very active trial practice up until his late 80s for over 3 additional decades after leaving the practice court program. Matt's advocacy in the courtroom was a testimony to the extraordinary gifts and the power of advocacy. He was an indefatigable lawyer, and he was fully deserving of that moniker, Mad Dog Dawson. The Mad Dog moniker was given to him, of course, by his practice court students. It stuck because it was so fitting. I admired Matt, along with the Legion, for who he was, how he lived his life, and for the example he set for all of us in the profession. Matt was the recipient of about every honor that you could receive in the legal profession. And I think the one that he perhaps was most proud of is he was named as a lawyer legend of the 20th century, late in his career. We have in the Law Center here a life-size statue of Mad Dog Dawson in his characteristic pose of an outstretched hand and a pointing finger. It is a statue that as the students pass, they can look to and they can say, that is a gentleman who I want to emulate in terms of what he did as a servant in the legal profession. Matt was deeply gratified by the commissioning of the life-size statue, and I think he regarded it as one of the greatest honors that he had received. But the other honor that he regarded as among the greatest that he received was when Mr. Jamail and Mr. Kronzer established this Endowed Lecture Series in his honor. And with that, I will now turn to Professor Fraley for the introduction of our distinguished lecturer. Professor Fraley.
Thank you, Dean. COVID has brought many challenges, but it has also brought great opportunity. And I don't know what it might have taken to get someone of Richard Suskind's caliber and pedigree to Baylor Law School for a lecture like this. So I'm profoundly grateful for the opportunity that technology has brought us for him to share his remarks with you. Professor Susskind got a first-class honors degree in law and computers from Oxford. And from there on, he charted a remarkable path. He's an honorary bencher at Gray's Inn. He's a fellow of the Royal Society of Edinburgh. He was conveyed OBE in the millennial round of such grants. But beyond that, he has reshaped how we can and should look at law and technology, not only systemically and how to achieve the goals that we want, but also reminding us of the importance that this should be client facing and that we should be advocates for a healthy system. Now, he's taken many of these ideas and spread them across other professions, finding those areas of intersection where the professions share commonality. In the course of this work, he has written many books, and I recommend them to you if you have not read them. He gives interviews. He rethinks how things should look. And I must say, he's fairly prescient. I think it was in the 90s that he predicted that a crazy new technology known as electronic mail might become the preferred medium for lawyers and clients to communicate. And I think he actually got sort of the polite British equivalent of death threats for suggesting that that might come to be. And yet now we see that he was right and forward thinking long before email became a part of our lives. I do have sort of a favorite quote because having been a practicing attorney, I know the challenges of working on the business when you are working so much in the business. And I think it translates for him to the profession. He recognizes the challenge of working on our profession while working in it, because he said, law firms tend to be so busy serving clients and meeting their financial targets that they allow little time for internal reform. It's not easy to change a wheel on a moving car. Well, as we careen forward on this moving car that is the future of the profession, it is my great honor to present to you the R. Matt Dawson Lecturer for 2021, Professor Richard Susskind.
Many thanks for these generous words of introduction, Liz and Brad. It's a huge pleasure to be with you. And be assured it would have been an even greater honor to have joined you in person. Unfortunately, I had never met Matt Dawson, but I've been reading up about him. I'm not sure as a great trial lawyer what he would think about what is about to unfold for you over the next hour or so as I present my ideas on the future of dispute resolution. But I understand he enjoyed a challenge. And so it is in that spirit that I thought what I would do is travel through 9 different issues with you, exploring the future of litigation. So I want to discuss the mindset that I think you need to have in thinking about the future, discuss also the impact that COVID-19 has had on the way we litigate and on court technology, and then take a step back and summarize what I take to be the global problem of access to justice. That'll lead me into a discussion about technology, and from there, quite naturally, to the world of artificial intelligence. From there, I will introduce a concept known as task substitution, which is an economist's way of looking at the impact of AI on our work. And then a concept of my own known as outcome thinking. I've been asked by Jim Wren to say a few words about civil juries. I'll do so with some considerable caution because I'm no expert, but I want to finish by talking about the future of our jobs. So that's for mindset. One of my favorite stories is about Black & Decker, the world's leading manufacturers of power tools. And apparently when they recruit new executives, Black & Decker take them into a room and put up a slide, much like the slide before you, of a gleaming power drill. And they say to the assembled new executives, this is what we sell, isn't it? The new executives look rather surprised by this. They say, of course, that's what we sell. We're Black & Decker. We're the leading manufacturers of power tools. The trainers, with a flourish and some satisfaction, say that's not actually what we sell. This is what they sell. And they put up this slide depicting a hole neatly drilled in a piece of wood, because that's actually what our customers want. And it's your job as new executives to find ever more creative, imaginative, competitive ways of giving our customers what they want. And I argue there's a great message here for lawyers, and indeed for all of us when we're thinking of the future. At a time of such change, I don't think the future is necessarily about, if I can put this metaphor to further use, a cheaper, quicker, lighter power drill. I think we need to take a step back and ask, what's the fundamental value we bring to those who secure our services? What's the hole in the wall in the legal market? So that's the first observation or question or challenge regarding mindset. The second relates to technology, and I'll say a lot about technology today, but the most important distinction that I make in the world of technology is between automation and innovation. Automation is what most people think of when they think of technology. You take some kind of task or process or activity, usually pre-existing, usually inefficient, but you apply technology to it. You systematize, streamline, optimize, improve, render more efficient using the technology. That's what most people think of when they think of technology. And that's dominated 60 years of legal technology and court technology. You essentially graft technology onto past practice. You automate the way you already work. There's a far more impactful use of technology, however, and we'll see this unfolding in so many sectors, including law in the 20s, and that's innovation. And that's when you use technology not to support and sustain and enhance our old ways of working, but to disrupt, to challenge, to displace, to replace our old ways of working. And this is the story of technology, a move from automating past practice to creating entirely new ways of working, ways that weren't possible in the past, ways that perhaps weren't even conceivable in the past. And there's no reason, as we see this technology, this distinction in technology playing out across our world, across various industries, to think that the most labor-intensive, the most document-intensive sector of all ours, no reason to think it will be exempt from technology. And then came COVID so tragically, and I hope I find as many of you as possible in good health. But it was very clear for those of us involved in a variety of ways in dispute resolution that the coming of this virus would have a huge impact. And what fascinated me was the rapid move from physical hearings to remote hearings. I was heavily involved in setting up, and it's still up and running, a service called Remote Courts Worldwide. www.remotecourts.org. And there we chart over 60 countries' response to the COVID crisis, how they've set up different sorts of remote hearings. And there's another sister site on virtual arbitration, which essentially charts similar developments in the world of arbitration. But in summary, remote hearings have come in three forms during COVID. The audio hearing, essentially the telephone conference, the video hearing, much as we're using today, and the paper hearing, which is not really a hearing at all. That's when the evidence and arguments are submitted in electronic form. There's an online exchange of messages amongst the parties and the judge delivers his or her determination in like form. There's never any oral evidence given. And that's why I wondered and worried that Matt Dawson might be a little nervous about what I'm about to say. But there's been the three options, and there's been some hybrid versions as well, a video hearing where there is an actual hearing and some people participate by video. But these are the three main categories. The dominant one in courts and in arbitration, of course, has been the video hearing during this difficult period. And in a nutshell, and I don't think it's to oversimplify, and there's lots of serious empirical study emerging on this, video hearings actually have worked fairly well. I think it's true to say that if most litigators had been asked a year ago how or the extent to which video hearings might be used in court, most have been very, I think, negative or pessimistic. And I think it's been a pleasant surprise for many lawyers and judges alike that video hearings can be conducted, not of course in all cases, but in many cases. Very good for arguing, certainly before the court, less good for cross-examination. And we're feeling our way through this. I think it's worth remembering of this technology, as of all technologies, that these are the worst, these video hearings are the worst they're ever going to be from now on. We're getting better and better at understanding how we might use video hearings. It's a great quotation from a science fiction writer called William Gibson, who once said, "The future has arrived. It's just not evenly distributed yet." And then I found during the COVID period, getting letters and emails from people who said to me, "Richard, your future has arrived. You've written 10 books on this subject. You've been thinking about this for 40 years. I think they were saying it's time to hang up your hat. Everything you're saying has now become a reality in 2 weeks rather than a decade that you'd expected." But I don't think the future has yet arrived. I think it's best to regard COVID as like a huge unscheduled experiment, pilot, consultation exercise, the rapid take up of certain technologies. And surely we should be gathering data, as much data as possible, from judges, from lawyers, from clients about what's worked well during this period, and therefore we should keep and industrialize, and what hasn't worked well, for which physical courts are still needed. So we should look at the COVID period, tragic though it is, but as an accelerated experiment in a number of technologies that court technologists have been anticipating for many years. But I say again that home working is not a full transformation. Dropping hearings into Zoom is not, as many commentators want to say, a shift in paradigm. Essentially, the people, the rules, the processes, and the problems of our current dispute resolution system continue within Zoom. We're just changing the user interface. I believe that actually we're just at the foothills of a fundamental technological transformation in the world of courts and the world of dispute resolution. But to explain how I get there, we need to go back to look at what the problems are with our current system. I've mentioned one, of course, that because of the virus, many hearing rooms are closed. Around the world in court systems, large backlogs are building up. But if we're really honest with ourselves, even in our most advanced legal systems, such as England and Wales, most civil disputes cost too much, take too long. The process is excessively combative. It's also unintelligible unless you're a lawyer. And I believe is increasingly out of step in a digital society. There's the problem too of the uneven playing field, where it's still possible for the wealthy and well-resourced to dominate those who are less well off. Other legal systems have more profound problems. Backlogs in Brazil, 80 million cases in their system. In India, 30 million cases. But the most profound challenge, I think, of all has been put down by the OECD, that has identified that only 46% of human beings live under the protection of the law. Only 46% have realistic access to lawyers and judges. For all of us working in the legal profession, this should be a source of collective shame. We have to do much, much better. And I don't think the answer, as so many people around the world say, is for public funding to be increased, to throw more money at the old system. Because if our existing system is inefficient, if our existing system is disproportionate, it's disproportionate and inefficient no matter who's paying. On the contrary, I think we need to go back to the drawing board. And in the spirit, I think, of the moment, we need to be asking a question that I've been, in fact, asking since the 90s. Is court a service or a place? Do we really need physically to congregate together to resolve all our differences? Or might there in the digital society be new, better, more convenient, less costly, less forbidding, more effective, more efficient ways of delivering court service? That's the challenge. Is court a service or a place? And if you accept it's a service, it opens up a whole new set of possibilities in the world of technology. So let's take a step back also and think about technology and what's happening in the outside world. I think you can look at the developments in technology under 4 headings. Nothing to do with legal technology or court technology. This is the world of technology more generally. Our systems are growing at an exponential rate, or in a sense, the underpinning technologies are. Processing power, bandwidth, hard disk, memory. Under almost any count, we're seeing this explosive growth in our technologies. This is enabling, and this is the big takeaway, if you want one phrase in terms of technology from this lecture, our systems are becoming increasingly capable. We can talk, and I will talk, about AI and all the rest of it, but the bigger point is our systems are taking on more and more tasks, many of which we thought not long ago could only be undertaken by human beings. Scarcely a day passes that we don't hear news of some breakthrough app, system, or technology involving a system that is taking on a human task. Our systems are also becoming increasingly pervasive, and not just the handhelds, not just the mobile phones, but the Internet of Things, chips embedded in everyday objects, communicating with one another and communicating with us. And more than that, we're embedding chips and software and routines within the working practices and processes of major businesses, of financial services organizations, of manufacturing plants, and so forth. And finally, we as human beings are becoming increasingly connected, and we've seen this so clearly during the COVID period, communicating, collaborating, cooperating in new ways. If you bring these four phenomena together, this explosive growth in the technology, that our systems are becoming increasingly capable, increasingly pervasive, and we as human beings are becoming increasingly connected, you see we're moving into a very different sort of world. Just to make this a little more concrete for those of you who are skeptical, think of the little card you might put in your camera. 2005, a good memory card, 128 megabytes. 2014, less than 10 years later, to 128 gigabytes, more than 1,000-fold increase in less than a decade. I was showing this slide at a talk in the US, actually not very far from where you are today, at Deloitte University last year. And the general counsel of SanDisk happened to be in the audience, and he showed me an early view of this. It's just quite remarkable. That's 1,000 gigabytes. It seems unstoppable, and frankly, for the foreseeable future, it is. Now, when I talk about machines becoming increasingly capable, of course, we talk about AI and so forth, but I also want you to know there are other fields going on, like affective computing, which I suspect very few of you will have heard of. That is systems that can both detect and express human emotions, a system that can look at your face and tell whether or not you're happy or surprised, angry or disgusted. There's a system now more accurately than any human being can listen to two female voices and tell whether or not they belong to a mother and a daughter. There's a system more accurately than any human being can now look at a human smile and tell whether or not it's fake or genuine. And so we're seeing these systems again becoming increasingly capable, detecting human emotions. And so for those lawyers who say it's so fundamental to the legal function to be able to read your client, detect their emotional state, we're already at the stage where these systems, at least some of them, are outperforming us. We can go further, systems that in a sense express human emotions. And I put this forward slightly lightheartedly, but it was part of a serious study. Ladies and gentlemen, I bring to you from the outside world news of the HuggyBot, and that's a system that will scan your face, determine your emotional state, and give you a hug, which in terms of duration and intensity is just right for that emotional state it has established. And in a remarkable empirical study, a serious one, it turned out that most human beings prefer a hug from the HuggyBot than they do from fellow human beings. Now, I'm not supporting this, I'm just giving you a flavor of what's happening out there. And we as human beings, as I said, are communicating in entirely new ways, video conferencing, telepresence improving, but also the idea of social networks coming into the profession, not for social purposes, but take patients like me. It's a social network for the recipients of medical advice, for patients. And the idea here is that patients, often long-term patients, exchange news and views and ideas and therapies and experiences with one another. And many say not only do they get more empathy and sympathy from fellow sufferers within the network, they often get more practical help as well. We find the same in religion, in architecture, in tax. We're setting up social networks that will soon become the first port of call before their professions for people who need guidance. I just mentioned these to give a flavor. The bigger point in many ways is there's no finishing line. No one in Silicon Valley or China, no one in South Korea just now is saying, job done. Let's plateau for a while. Enough is enough. Enough doesn't seem to be nearly enough in the world of technology. Our technologies are advancing at an accelerating, explosive rate. And I believe our lives will be transformed, both our working lives and our social lives, by 2030, probably long before that, by technologies that haven't yet been invented. I can't prove that, but that's the trajectory we're on. Which brings us to the world of AI, which to some extent, which I'll explain, is my home turf. The field of AI and law, in my view, was born in the 70s, with an article published in Stanford Law Review by Buchanan and Hedrick, and one 7 years later in Harvard Law Review by Torrin McCarty. These were the people who first thought seriously about the use of AI in law. And I joined the field in 1981 as an undergraduate in law at Glasgow University. I wrote, left-hand side, my dissertation on computers in the judicial process. So it's my 40th anniversary of thinking about technology, of artificial intelligence in the law. I went on to Oxford to write my PhD, my doctorate on AI and law as well. So it's been a lifelong interest of mine. And so with some confidence, I say this to you, that you will hear a lot about AI in the law. Almost everything you hear by way of short-term predictions, I believe hugely overstate its impact. But, and it is just a huge but, almost all the long-term predictions hugely understate its impact. Will technology, will AI fundamentally transform the work of lawyers and courts over the next 2 or 3 years? Of course not. By 2030, most certainly yes. And this defines for us our challenge. The 2020s will be the decade where technology moves, as I said, from being automation to innovation. And one of the key innovative technologies that will be, let's be clear, replacing a lot of human lawyers will be artificial intelligence, not over the next 2 or 3 years, but towards the end of the decade. Let me take you on a little bit of time travel to put some flesh in these bones and talk to you about the first wave of AI. I finished my doctorate in '86, and I went on to develop the world's first commercially available AI system for lawyers. I wanted to get my hands dirty. I wanted to develop something that implemented the ideas I'd had. I was approached in '86 by a man called Professor Philip Capper, who was the former dean at Oxford University and had written a book on a new area of the law of limitation called latent damage law. And he showed me this extract from the Latent Damage Act 1986. Section 2 of this act shall not apply to an action to which this section applies. English is my first language and I don't understand that, and neither did most of the legal profession. Philip said this legislation fundamentally changes the law of limitation and no one is understanding it in the construction, manufacturing industries and the professions. No one seems to understand the book either. So the idea, it's so complicated, he had was that we might use the techniques I developed in my PhD to develop a computer system, an AI system, we call them of this sort, an expert system that could answer the question, when can I no longer raise an action because too much time has elapsed? When is my action time barred? And this was the front screen of the system we developed, the Latent Damage Act system. I want to assure you in '88, when that was launched, that we felt that was cool. It was generally acknowledged as cool. It was a good design. It looks woefully, embarrassingly out of date now. This was in the era when floppy disks genuinely were floppy. And we developed and loaded our system in 2 5.25-inch floppy disks. We wrote a book on the development process and we put the floppy disks in the back. And the system was made available to people who had, at the time, an IBM compatible PC. So how did it work? And this is crucial to understand the first wave of AI. Essentially, what we built was a decision tree, a huge flowchart, over 2 million paths through the system that we ourselves mapped out to reflect and capture and represent a complex piece of legislation, a huge body of case law, and Philip's personal interpretation of this area of law, a massive 2 million path decision tree. And basically what you were offering was non-experts the opportunity to navigate through this complex area of law, and you needed to know nothing about it, a system eventually that reduced research time from hours to minutes, a system that Philip, the leading expert, said to this day outperformed him. It never had a Friday afternoon syndrome. It never had a hangover. Relentlessly, rigorously, systematically, it churned out the right answer every time. And folks, that was more than 30 years ago that technology existed. You might wonder why there are not many more of these systems around. Well, there were 3 things we didn't anticipate at that time: the coming of the World Wide Web, brute force computing, and machine learning. Let me just say a little bit about each. The web, I don't know how many of you joining me today remember when the web came along, but those of us who were involved with technology, it was mind-blowing. We couldn't believe it. The idea that you could make documents, material, content available online, accessible to anyone around the world, and likewise that you could access information and documents and materials around the world, it was phenomenal. And we were so attracted by I mean those of us working in AI and law, were so attracted by the web that we actually moved away from the AI. There was an immediacy, a practicality, a commerciality about the web. And most of us moved to providing content, guidance, and advice in the web. AI had a winter at that time that lasted many years. But what we hadn't anticipated also in AI would be the developments, this exponential increase in the processing power of machines, such that our eyes were opened again to AI in '97, when Garry Kasparov, the world chess champion, was beaten by a computer system called Deep Blue. In the '80s, we thought that wasn't possible. Well, what we hadn't anticipated was that this system, by the time it played Kasparov, could explore more than 338 million possible moves in 1 second. A good chess player can juggle maybe 100 moves in his or her head at one moment in time. So no, Kasparov was not really beaten at the same game. The system was working in a very different way. And we hadn't anticipated systems could use huge amounts of data and process at such rapid speeds. And this takes us to the third point, and this is the most fundamental change in many ways in AI, where we move from systems that we explicitly programmed, that we coded the knowledge into, to systems that learn from huge amounts of data. Now, most of you will have heard of machine learning, of data science and all the rest of it, and you'll probably nod, but I just want to give a little bit of an explanation about what's going on here. The best way I think of understanding the difference between systems that we program and systems that learn is to think about how I learned to speak French when I was at school in Glasgow. I was given a list of words and I was given rules of grammar, and I put the two together, and the result, I have to tell you, was not very impressive at all. I had a couple of friends who went to Paris for the summer and they came back apparently fluent. They don't remember learning any words from a list. They don't even know the rules of grammar, but they had absorbed from watching the television, from sitting in cafes, from going to the cinema, from listening to the radio, from reading the newspapers. They had absorbed the language. And in a way that the linguist Chomsky has led us to understand, we seem to have this innate ability, this capacity, if we have enough data, to convert that into some kind of faculty with language. Now, this way of learning is far more like machine learning, absorbing huge amounts of data and changing that into an ability to speak a language. What we now have is systems that take in huge amounts of data and can identify correlations, patterns, trends that we as human beings don't recognize. They can make predictions in huge amounts of data. They can essentially solve problems. And that's why in medicine, for example, you have a system that can outperform any dermatologist. It can look at an image of a lesion and tell whether or not it's a melanoma more accurately than any skin doctor. It has 127,000 past images of lesions together with the results of the pathology. It puts them together and it performs at a high level. But you might say, as many people say, I'm a lawyer, I'm creative. A system can never be creative. Think about AlphaGo. Go is a board game, way more complicated than chess. There are more permutations in the game of Go than there are atoms in the universe. And it wasn't that many years ago that leading AI scientists said, a computer system will never, at least for a decade, play a good game of Go. It's too complicated. And then a couple of years later, a system called AlphaGo, developed by Google's DeepMind company in London, developed a system that beat the world Go champion 4 games to 1. I want you to think of the second game and the 37th move. You can see it on YouTube. The machine moves the piece. The commentators think it's a mistake. No human being had ever thought of that move before. Another Go champion later described the move as beautiful and said it brought a tear to his eye. In human beings, we would have called that move creative, imaginative. We may even have called it genius, but it was none of these things. It was brute force computing, huge amounts of data, clever algorithms. And that, ladies and gentlemen, that trilogy, that trinity, is the combination that will take on so much professional work in the future. But you might say, Richard, you don't really understand what I do as a lawyer. I think, I reason. A computer can't do that, and therefore my job's safe. And I say to say that is to commit the AI fallacy, which we define as the mistaken assumption that the only way to develop systems that perform tasks at the level of experts or higher is to replicate the thinking processes of human specialists. And this is an extremely anthropocentric way of looking at the world. It's thinking that the only way computers can perform at high levels by copying the way we work. Why would they want to copy the way we work rather than using their distinctive capabilities? This ability to handle huge amounts of data, to execute algorithms and so forth. And you can see how daft this really is when you think of self-driving cars. No one is putting this forward as a recipe for the autonomous vehicle. The idea that you developed a robot that sits in a normal human car, copying how a human drives. For a vehicle to work, it doesn't need to have nostrils and elbows. It can be developed on the basis of huge amounts of data. Cars that have driven hundreds of millions of miles, that have absorbed and captured and rendered meaningful lots of past journeys, unimaginably large number of past journeys by human beings. And so what these systems essentially are doing when they operate autonomously is predicting what it is on the basis of all that past data a human driver would have done. That, in the broadest of terms, is how they work. You don't program to work them explicitly, they draw on that past data. And this is the era we live in. It's the era of increasingly capable, non-thinking machines. These machines don't have cognitive states. Forget all the nonsense you hear about cognitive computing. The machines have no more cognitive states than the carpet beneath your feet just now. But the second wave of AI are still outperforming us. So where does this take us in the world of litigation? Well, let's look at this concept of task substitution that economists talk about in relation to technology. They analyze the work of human beings, break them down into tasks, and say which tasks might be undertaken better as well as robots, and which task might be best to leave to human beings. So let me give you a list, and it's not exhaustive, but it just gives you a flavor of some of the tasks involved in litigation. So many of you watching and listening today are way more experienced than I am, but I hope you will recognize the broad direction I'm moving in. Document review, research and analysis, project management, prediction of outcomes, disclosure, strategy, tactics, judgment, negotiation, oral advocacy, indeed the determination of the case. So my question is, which of any of these might machines take on? And I just want to give you a flavor of how this might look. So let's have a look at how document review might be done by AI, prediction, the exercising of judgment, and even determination. I'll look at these four to give you a sense. Technology-assisted review has been with us for so many years. In terms of precision and recall, if you've got a large body of documents to review in litigation, we know that these systems can outperform good junior lawyers, paralegals. This was established in a paper in 2011, and the technology a decade later is wildly better. It's an interesting question to ask why it's not more widely used. It's certainly that it doesn't function well. Whether or not it's the comfort zone or the profit zone of lawyers is another question altogether. But let's be absolutely clear that review of large quantities of document is by and large better done by machines than by human beings today. What about the idea of prediction? And this is fundamental, isn't it? Lex Machina, you may have heard of, a system that was developed by Stanford University, bought by LexisNexis. Many things are said of it. One is that it can predict the outcome of patent disputes in the United States more accurately than any human patent lawyer. And here's the kicker, folks. It knows nothing about patent law. It's not working in the full text of judgments. It has information about 200,000 past cases, who the judge was, who the party was, who the lawyer was, the nature of the claim, the size of the claim. It turns out if you have enough objective information about past cases in sufficient quantity, then computational statistics can give rise to a more accurate prediction of court behavior and court outcomes than the legal method. Now, hold on a minute. Many lawyers say to me, this is dangerous. It knows nothing about the law. But I ask this question. What is the question that every client asks when there's a dispute coming over his or her horizon? What's our chances of winning? Do you remember the organizational psychologist Abraham Maslow once said, if you're a hammer, everything looks like a nail? Well, I think if you're a lawyer, everything looks like a legal problem. And so when a client says, what's our chances of winning? Our tendency as a lawyer is to think that's a legal question, but it's not. That's to look at power drills rather than the hole in the wall. The client is wanting a probability. That's the outcome. And if computational statistics can give that probability more accurately, more cheaply, more conveniently than the human lawyer, the market will in due course prefer that if it's demonstrably the case. So even in prediction, we're seeing systems that are knocking in the door of outperforming human beings. But Richard, what about judgment? That's what my clients come to me for. How on earth could a computer system ever exercise judgment? And I say that's the wrong question. Here's a better question. To what problem is judgment the solution? Or in other words, why is it that clients require of us that we apply our judgment to their problems? Well, I think we should be quite clear. Very few clients come into law offices and say, good morning, I'd like some judgment, please. They actually come in under conditions, I believe, of uncertainty. This is the fundamental problems clients have. They're in circumstances, they're uncertain how to classify or categorize them from a legal point of view. And they're uncertain about the legal consequences. They do not know the rules, the regulations. They do not know the significance from a legal point of view of their circumstances. So they will say things like, in your judgment, in your experience, what's the position? But the answer, if you believe, as I do, that one of the fundamental problems that clients suffer from is uncertainty, is not can a computer system handle. This is the power draw confusion. It's not can a computer system handle judgment. It's because that's the power draw. It's can a computer system handle uncertainty, the hole in the wall. And you bet that's the story of big data. These systems that are handling judgment to such a high degree. Are they handling judgment? No, they're not really. And I go back to my dad as a retired dermatologist. And he was the man who showed me that system that diagnoses melanoma. And he was saying it's interesting as a dermatologist that, and I suspect few people know this, but most dermatologists, unless they're specialists, skin cancer specialists, they don't see more than 200 or 300 melanomas in their career. That system, the Stanford system, had 127,000 images, as I mentioned. And so my father, he said, when he heard that, thought, well, that's going to outperform me, because what I call my experience, often what I call my judgment, is my limited database of past personal interactions. And so when I hear a system with 127,000, it's going to outperform me. So this is the idea that huge amounts of data can, in a sense, it's not replicating the way we judge, but it's delivering the outcome the clients want. So I've said a little bit about some areas of dispute resolution that might be affected. We've talked about prediction, we've talked about document review, we've even talked about the exercise of judgment. The most controversial of all is predictions as determinations. So in the dispute resolution process, of course, there's a determination made. And the question I've been asking for 40 years, in a way, has been, could a machine ever replace a judge? Now, if the question there being asked is, can a machine physiologically and neurophysiologically and neuropsychologically replicate, copy the way a judge thinks? Of course not. What about a machine that can produce decisions with reasons? Because that's essentially what judges and arbitrators and others do. Well, AI in law is not at that stage yet. It's just not developed enough to provide well-reasoned conclusions to complex or indeed fairly simple legal issues. But there's another possibility. And that's the idea of predictions as determinations. Just want to remind you again of the Lex Machina story, these systems that predict the outcome of courts to a very high degree. And I want to take you back to Brazil with a backlog of 80 million cases. With all in the will in the world, these cases are never going to be sorted out, are they? Let's be honest, by human lawyers and human judges. It would take centuries. But what about this as an alternative? What about if you developed a system that captured, in particular areas of law, all the past decisions of judges in the jurisdiction? And if parties had problems within that problem area, the court service could say to them this: your case cannot be heard until 2088, but we do have a system that actually has indeed all the past decisions in your problem area. And it can predict the most likely outcome of our court in your problem area. Would you, saying to the parties, accept the prediction of such a system if its degree of confidence was, say, 95% or higher? Would you accept that as a binding decision of the court? Every bit as binding as a human decision. Now, I'm not saying to you, this is definitely an idea. Well, it's definitely an idea. I'm not recommending it to you. I'm putting it forward as a thought experiment, a way in which, and it's a radical way in which we might use technology in the judicial process, in litigation. And of course, there's the two standard problems that everyone comes up with in AI, the opacity of the data, because the systems I'm talking about can't explain their lines of reasoning, not like the first generation of AI, and the bias within the data. These are issues we can perhaps discuss at Q&A, but they're very much the focus of the AI research community. So there are all the tasks. And what I'm saying to you, as I walked around each one, we're seeing at least some, as my son Daniel in his book, A World Without Work would call, task encroachment. We're seeing the encroachment of AI, of these increasingly capable systems, on many of the tasks that make up dispute resolution. And for many people, that's the end. But actually, I argue that the technology goes even further than this. I want to introduce you to an idea I call outcome thinking. I was asked to give a talk in Boston at the end of, it was 2017 now, to 2,000 neurosurgeons about the book I'd written with Daniel called The Future of the Professions. And these neurosurgeons asked me to be controversial. So my opening line was this. I said, patients don't want neurosurgeons. There was a gasp in the audience. I said, patients want health. For a particular type of health problem, I said, you're undoubtedly the best answer we have today, and God bless all of you for the work that you do. But if we look, say, 30, 50, I don't know how many years ahead, do you not think we'll look back and think it's unbelievable we used to cut bodies open, how primitive that was? Because the future of neurosurgery is not really neurosurgery. The future of health is non-invasive treatment. You're asking the wrong question, in fact. If you ask what's the future of neurosurgery, you should be asking how in the future will we be solving problems to which you are the best answer today? And the answer to that is not robotic surgery, it's non-invasive treatment. And that then leads me to this question about the future of litigation. Everyone asks this question, what's the future of litigation? So I see, of course, that's the wrong question. The better question you should be asking is, how in the future will we solve the problems to which litigation is our current best answer? Because the key point to note here is, and it's hard for all of us to accept this, people don't want litigation. People don't want courts, they don't want lawyers. They want the outcomes that litigation brings. And if we can find different ways of delivering these outcomes that doesn't involve congregating in physical courts, that doesn't involve spending disproportionate amounts of money, often on lawyers, if we can find ways that are far more widely accessible, that can help us beyond 46% of people in our world, only 46% having access to court services, I think we should open our minds to this. And that's why I wrote a book called Online Courts and the Future of Justice. This was I joke that I write the same book every 4 years. So this is my 10th one, but it's not that my running theme is we can use technology to improve our justice system. And this was my latest effort to look at the courts. And I've been technology advisor to the Lord Chief Justice of England and Wales, our top judge in England and Wales, since 1998. So I'm advising my 6th Lord Chief Justice now. This has been a huge part of my life. And so I wanted to bring the thinking together and advocate a new way of resolving disputes. And I can't in detail expose you to this today because I'm conscious I have perhaps 10 minutes to run in my presentation. But I do just want to give you a hint of what I'm about here. For me, online courts have two fundamental components. The first is asynchronous online judging, and the second is extended court services. Asynchronous is a funny word. Communication is asynchronous when the people communicating have to be present or available rather at the same time. A phone call, a meeting, a video conference. You have to be available to communicate. Asynchronous communication is communication where you don't need to be available at the same time. A text message, an email, a WhatsApp message. And the idea that I and others have had is that we can, for many cases, particularly high volumes of low value cases, provide judges on an asynchronous basis. It was a little like the paper hearings I mentioned earlier on, that the parties submit their evidence and arguments in electronic form, and the judge engages in some kind of online exchange of messages and debates and arguments with the parties. But it's all done asynchronously. They don't need to be there at the same time. There's no oral hearing. It can be done in the comfort of one's home. It can be done from the kitchen table. It can be done at night. There's no days off school. There's days off work. What we're doing is using this technology. Again, I'm saying not for all cases. And I know many high-powered litigators will say this doesn't work for my kind of case. And my main argument in the book is I'm looking at low value, high volume civil cases. Although that said, those of you involved with international arbitration will know quite a lot of very high value complex issues are decided in the papers alone. But the idea is asynchronous online judging as an alternative, quicker, cheaper, more convenient in many ways than conventional judging. But that's less controversial than the second component, extended court services. I believe in a digital society and a society in which very few people genuinely have access to justice. The state can do far more to help people who have some kind of justiciable claim. I don't think it's enough just to provide the primary function of the court service, the delivery of binding decisions. I think we need to help people understand and enforce their entitlements. We need to provide tools that can help people understand their rights and duties, understand the options available to them. We need to provide court users, and this is self-represented, pro se, litigants in person, people representing themselves. We need to provide them with tools to help them organize their evidence, to actually structure their arguments. We can do this now. We have the tools for that, to empower far more people, to help them understand their entitlements. So I have this idea of access to justice being the combination of understanding and enforcing your entitlements. And in the understanding also, we go beyond that for the extended court service to help people, for example, use these predictive tools so they can understand the likelihood of their case being settled one way or another. I also believe that we should provide online ADR, e-mediation, e-negotiation, tools and techniques to help parties come to some kind of non-judicial settlement. And the key here is not as a private sector alternative, but baked into the system. So I have this very different view of an extended court system, of online judging and extended courts. And that's the one, and it's going to be for the next few years of my life, I want to try and build some standard tools to take across to developing countries, because this, I believe, is how we can increase access to justice globally. But there's a very interesting message here for oral advocates, because oral advocacy, if you do task substitution as your exercise, oral advocacy always survives, because people rightly say, well, there's no way a machine could stand up in court and give a soaring closing argument. But if more and more cases become, in the way I'm anticipating, conducted through online synchronous hearings, there is no more oral advocacy, or not nearly as much. And so it's to miss the point to think that the work I do can't be done by a machine, because in parallel, we're seeing fundamental, elemental changes in processes, such that if there's a huge reduction in the amount of oral advocacy in the system, the argument that a machine cannot undertake a closing argument dissolves. Oral advocates in principle may become like mercers of yesteryear, the people who worked in silk. We don't have mercers anymore. We have new ways of manufacturing and distributing silk, but it's not based on that profession. And that leads me to a fundamental question that all of you as lawyers need to ask. What business are you in? My favorite management article is by a man called Ted Levitt. And Ted Levitt wrote this article in 1960 in Marketing Myopia. And he's keen to try and encourage people to think about the fundamental value they bring, the hole in the wall, as it were. And it's interesting, he said the reason the railroad companies failed is because they thought they were in the railroad business. In fact, they were in the transportation business. So I ask you, what business are you in? You're certainly in the dispute resolution business, but I believe you're also in the dispute containment business. I believe we owe it to the users of legal services to help put a lid, to de-escalate their disputes, rather than let them run riot through the court system uncontained. So I believe in tomorrow, access to justice should be defined not just in terms of dispute resolution, but in terms of dispute containment too. Containing problems, absolutely vital, but even more vital, dispute avoidance, what I sometimes call putting a fence at the top of the cliff rather than an ambulance at the bottom. This is what most general counsels say they want. Risk management. I've not yet met a chief executive who prefer a really big legal dispute well resolved by a vast team of lawyers at great expense to not having a legal dispute at all. That's not how the normal mortal thinks. People want fences at the top of the cliff rather than ambulances at the bottom. And that's the future in many ways of dispute management. I've been asked to say, and I forewarned you, it'll be a very amateurish and quite quick set of comments about civil juries, because I'm very conscious that we have, for example, Article 6 in Europe, which talks about the right to the public trial or hearing, and people say, well, that isn't public in the way you're anticipating in your online courts. And people have said similarly, what about the constitutional right to civil juries? How do we preserve, and Jim Wren put this question to me, how do we preserve the jury trial in the digital age? And I just want to give you a scheme of thinking about this. I'm not going to answer the question because it's a profound one, but here's how I would go about answering this question. With these emerging technologies, and you're asking about the preservation of the jury trial, I think on the one hand, you can say, to what extent can automation be used in the preservation of the jury trial? And some people have tried, for example, as I say, dropping a jury trial into Zoom. I think that there are fundamental problems with that. I don't think in any of the research or evidence I've seen, and it's pretty paltry so far, that we should in any sense rush in simply to automating the jury by dropping it into video conferencing system. But there is the opportunity to explore how the various aspects of the jury's trial might be automated, streamlined, and improved. A second approach to this question of preservation of the jury trial is innovating, which is to say it's still using technology, but wondering whether or not there'll be other technologies that can be used in the delivery of a jury trial. It might be, for example, and I haven't mentioned this enabling technology today, virtual reality. Virtual reality is proceeding at a phenomenal rate, a new way of meeting, convening, sharing, cooperating. We haven't begun to think what it would be like if jurors put on head-mounted displays and participated in a jury trial in an entirely new way. That would be an innovative use of technology. It may well be you could expose jurors to a jury trial. They could be remotely located more effectively and with a wider range of services than through traditional techniques. But I want to take a third approach. I talk about automating and innovating. And I want to put the question again that was put to me, how do we preserve the jury trial? And as is my way, say, I think that might be the wrong question, and go back to my idea of outcome thinking. Because it seems to me the more important, the better question in some ways, how in the future might we preserve the values, benefits, and outcomes currently secured by civil jury trials? The civil jury trial, in my view, as with almost all the processes and procedures within the legal and court systems, I don't believe they're intrinsically valuable. They're valuable because they bring about certain outcomes and they preserve certain values, benefits. So my question and challenge is not so much what's the future of the jury trial, but might in the future there be better ways? Might these values, benefits, and outcomes be secured by advanced technologies and even systems that are not yet invented in a way that preserves everything that is important to the jury trial, but adds a whole lot more on? And that could give rise to new thinking about this fundamental constitutional issue. So I think it's to miss a trick to say, in the COVID era, can we drop a jury trial into Zoom? What do we lose? I think there are far more advanced technologies that might enable us to deliver something that is a quasi jury trial, but to some extent virtual. But I say to you, the bigger challenge intellectually, constitutionally, I think, is to ask the question, how in the future might we preserve the values, benefits, and outcomes currently secured by civil jury trials, and might advanced technologies and these as yet uninvented systems secure these values, benefits, and outcomes to a higher standard? So the final thought for you as I come to the end of this presentation is about jobs, because I'm conscious there'll be some young lawyers, hopefully some students listening, and many people who've got a little bit of game yet who are going to be around for a decade or two and want to know, what does this mean for our jobs? And I want to ask you to think about this list. Just take a glance through these individuals and see if you recognize any of them. I suspect you socialize with very few. They're not people with whom you'd come into contact. Who are these people? Well, these are the people who'll be developing the systems that will replace our old ways of working. These are the people who'll be developing the systems that will provide solutions by way of technology to legal clients. These, ladies and gentlemen, are tomorrow's lawyers. And you may bristle at that and say, well, that's not a lawyer, didn't go to law school. But I don't think we should define lawyers in terms of our education 20 or 30 years ago. We should define lawyers as people who help people with legal problems. And if, as I believe, we're moving into an era where these increasingly capable machines will encroach in some tasks, legal tasks, and render some irrelevant, then it seems to me we have to look at the new generation of people who will be developing the systems that will be replacing our outmoded, our outdated ways of working. And so the big question for all legal businesses and for your individual career is this: do you compete or build? By competing, you're saying, I've heard everything Richard said, he doesn't really understand what we do. There's no way a machine will ever be replacing my work in the future. I'm happy to hang on doing that kind of work. And that's the strategy of our business. Well, I say to you, you're not wrong. Oh, you're not definitely wrong, but you're pushing against the tide. If you believe in the thesis of increasingly capable systems, if you look at any economist's analysis of the new division of labor between machines and human beings, the slice to the human beings is getting smaller, the slice to the machines is getting bigger. But you can choose as a career, as a strategy, compete with these machines. But I would say you're missing out in the excitement. You're missing out in the commercial opportunity. And for young lawyers coming through, I say to you this, that never really in living memory have law graduates had the opportunity to come into the profession to help change the way we offer access to justice, to help improve our justice system, to help upgrade the way we work as lawyers. Now, some of you I know will hope you can hold out to retirement until all of this engulfs you. But actually, I look at this image rather differently. I think this is an online judge taking inspiration from nature and putting the finishing touches on his online judgment. Thank you very much for listening, ladies and gentlemen. Back to you. Liz.
Thank you, Richard. Fascinating. And we've had a wonderful series of comments and questions. So I'm going to try to aggregate some of the ones that have common themes. There's certainly a number of our watchers who find you compelling, who believe you make an excellent case and would like to build. And a common theme of some of these questions is how? What should we do next? And what can I as an individual do now? What would be the most important technology to adapt or adopt? What skills to accomplish? Give us some breadcrumbs to follow, please.
Well, for me, the primary task now is one of education and learning and retraining, and every other industry and sector is facing this. You've got a responsibility at law school, and we've got a responsibility beyond to, I think, retrain practicing lawyers in a number of the skills that I put up before you. And this is a huge challenge because many law professors, many law schools already, they have very busy curricula. And in my view, and I'm not for a second talking of your law school, but as a generality around the world, we're generating 20th century lawyers rather than 21st century lawyers. We're generating people who are fit for purpose for legal practice in the 90s, but not in the 20s or 30s. And so what I recommend, and I've written a book called Tomorrow's Lawyers, which addresses this at length, it seems to me that the secret, at least for law schools, is to provide options. I think the study of the future of legal services, the study of the future of courts, there's enough of a literature, there's enough serious work there that this is something that students should be able to study, and practicing lawyers too. I think too that skills like legal knowledge engineering, legal risk management, legal process analysis, they should be offered within law schools. But I think not compulsory, but as options, because I'm conscious of the busy curriculum. That said, those law schools who've actually offered these options, they find them oversubscribed. Because if I'm borrowing as a law student, the amount law students are borrowing, I want to equip myself for the 20s, not for the 90s. So a huge responsibility, I think, and burden on the law schools there for them to transform as much as law firms need to transform. As for law firms, again, they need to I think, retool and retrain. And there's always the question asked of me, should we be involved or should we get technologists within the law firm? And I think there's a bit of both. I think lawyers can be hybrids and, for example, can develop document drafting systems using basic tools. But if you're wanting to work on legal data, if you're wanting to develop serious projects at scale, you're going to need to have different people working within your business. And this is a huge challenge because most law firms, you mentioned earlier, hard to change the wheel in a moving car, but we're used to a business model, a fundamental business model where we charge for human time. And I'm saying we're moving towards a model where we productize, commoditize, systematize, make available content, guidance, advice, solutions online, which means actually it's an entirely different model. You're licensing your knowledge. The great thing about that is you can make money while you sleep. So that's the challenge. So there's an educational challenge. But as to the question where you begin, you're looking at the wrong end of the telescope if you're asking me about technology. You begin with your client's problems. You begin with thinking, what problems do my clients have that are perhaps rather routine or repetitive, that we think we've got a deeper expertise than others, that we can perhaps solve in a different way. The starting point isn't, oh, I've got a document generation system, or I've got a system that can review documents in due diligence or in litigation. The market opportunity is to identify your client's biggest problems and find technological solutions to these. And you will need technological help with that. I think also you've got to differentiate between what was perhaps in people's minds a little bit of piloting and experimenting, which is important. And I think it is quite good. I think every lawyer should have to develop their own document automation system. You can learn how to use some of these packages very quickly and immediately gives you a sense of what's involved. And piloting and experimenting is good. But once you get beyond that, beyond what I call the first generation of innovating within law firms, I think it needs you need help with professional system development. You need, above all else, in many ways, user-centered design. This is the whole idea of design thinking that's absolutely prevalent within the technology community, that we have to develop systems for end users rather than technologists or for lawyers. And so I wish, when I'm asked that question, a slightly critical observation I often make is what lawyers want is off-the-shelf competitive advantage. They want to know the answer. When I do masterclasses and one-day workshops in technology, people want to say, what system should I buy? And I say, you're asking the wrong question, because you don't start at that level. You start off thinking, what are clients' needs? How innovatively, in a differentiating way, can we meet these needs? And then what enabling technologies can deliver what our client wants. But before all of that, and why it all seems slightly hopeless, is you need to immerse yourself in the fields. You need to understand more about legal technology. And we're lucky that there are books and websites and resources available. But this is an opportunity, if I can pass along to Liz and Brad, I think it's a great opportunity for the universities to collaborate with the profession, the practicing profession, and a great opportunity for executive learning, but actually a great opportunity, frankly, for students and lawyers to sit in the same room. This is the transformation. We live at a time of greater technological progress than humanity's ever witnessed. We have to expect that during the 20s, we'll have to retrain and reskill considerably. And so, as I say, if this all seems a little bit hazy, it's because you haven't yet immersed yourself in the field. That's what you've got to do. You've got to go about this with the energy and enthusiasm that you would tackle a new case. You've got to apply that to this new discipline because it's your future.
Richard, in a corollary, we've got a wonderful question on what your ideas are on improving the issue of only 46% of the world being protected under the law. And the question is specifically, what can young lawyers or law students do to make an impact?
Well, what I have in mind, and I outline it in my book on online courts, but I'm going to be launching something this year. I think I've been struck by the global cooperation in the medical world during the virus and how effective that's been. I've been struck also by, in the online dispute resolution community, how people are just doing their own thing in individual jurisdictions. Seen that in remote courts, 60 different jurisdictions doing their own thing. So first of all, I think we need a global initiative. But the idea I present is that we should be able to develop a standard platform, a technology platform that provides all the facilities I've been talking about, whether it be at a very basic level, video hearings, but more importantly, an infrastructure for asynchronous hearings, an infrastructure to allow the introduction of modules that can explain difficult areas of law. I think there's a huge standard toolkit tailorable for specific jurisdictions that we can develop and make available across the world. I'm always amused when people from developing countries come to England and they say, we'd love to see your courts and copy them. I say, I don't know why I want to copy them. We're trying to replace them with technology. You should be leapfrogging. But it's so formidable across the world. How do you kickstart an online court service? How do you develop this? And I'm saying, well, we don't. What we should do is have a global effort to produce a standard platform that any country could get up and running very quickly. And then what we need to do is a global movement. This is where students come in, I think, to help essentially, remember I said there's two components, systems to help understand the law, and system to help enforce your entitlements. The understanding the law, the big decision trees. If you look at the best example in the world's Civil Resolution Tribunal in British Columbia. Now there they've got something called Solutions Explorer, which is essentially for the various areas of law that tribunal has jurisdiction over. It has, a little like my latent damage system, reduced the area of law to very easily usable but complicated decision trees. And that's what we're going to need to do in every jurisdiction across the world. And that, I think, will have to be a charitable activity. So we want to have the tools to help do that and build the community of willing, and I think it will be young lawyers who will build these facilities. So you identify the 10 or 15 major problems, legal problems, everyday legal problems that people have in individual jurisdictions, and you map out these decision trees, and you provide all these other tools. So I think it's a global initiative of the standard platform, tailorable for particular jurisdictions, and the content is provided locally. So that's what I want to spend a lot of the next few years of my life doing, and hopefully build an international program around that. It's the only, I don't see that we can solve the global access to justice problem simply by thinking we can throw more lawyers and judges at it. I also don't think the answer, as many people think, is just to have better online guidance. You need, having online guidance of its own, it doesn't have the teeth. You need to have the teeth of a court system there. And the other thing, I think this is a little bit of a Trojan horse, that if we can introduce these to countries that are perhaps rather lax in relation to the rule of law, if it's easy to build some kind of capability that helps people understand and enforce their entitlements, that puts, I think, an additional international pressure on states that are not fulfilling their duties. So that's very roughly, I'm currently writing a paper explaining all of this, and a number of law firms have come forward and said they want to fund it. So that's the plan. So for me, it's putting the theory into action. I've seen it work sufficiently in court systems to say the technology works. What we need to do is make it available. And incidentally, I should say 59% of people in the world have access to the internet. 46% of people access to justice, 59%. So my project may be called 4%, which is, just imagine if this technology allowed access to 4% of people. That would change the lives of hundreds of millions of people. So for those who say, oh, what about the 31% of countries, or 41% of countries rather, or people who don't have access, all we need to do is work on 4%, and we've made a huge impact. So
light a single candle before you sit and curse the dark.
Indeed that.
Yeah. Well, and, not to be the crass American, Richard, but how does this get paid for? I'm happy to be the crass American, actually, that economics background. But let's think about, so who has the incentive, who has the carrot, the stick to institute some of these changes in the US? As you point out, in-house counsel at corporations are under tremendous pressure to control legal spend. How do we push, drive, coerce to get this going?
Yeah, and that is a different question in the US from how do we get impoverished countries in Africa to access these systems by the handhelds, where the problem is they don't have access to electricity. It's a very different problem. But so what you're really asking is the fundamental question that everyone in legal technology and technology asks, is how do you bring about change? One observation to make is people often say, well, lawyers are very slow to change and judges are very slow to change, very conservative. We've seen during the COVID period that that's not right. If the platform is actually burning, if the iceberg is melting, what we've seen is a remarkable rapidity and adaptability. We've seen new court procedures, we've seen new technologies, we've seen entirely different working practices, and lawyers and judges have moved very quickly. Within days, they've changed their working practices to accommodate. So I don't buy the argument that somehow lawyers are institutionally or pathologically incapable of change. The bigger point, though, is, and this is your question, any theories of change, and there's lots of work written about this, but generally phase one is to create a sense of urgency. And I often say of lawyers and law firms, it's of the big firms I speak to, this is a deeply unpopular comment coming up, it's hard to convince a room full of millionaires that they've got their business model wrong. Because the reality is, if you're raking it in through high value litigation, then you're sitting thinking, this is just not for me. I don't see this. So law firms and lawyers are generally not incentivized. The client should be, and this is why what's so very interesting in the US is the extent to which a number of enlightened general counsel are coming together with people like the chief operating officers within big legal departments and collaborating. Clock is a good example of this. And I believe I've no desire to make law firms poorer, but I do have a desire to increase access and to deliver a proportionate service. And I think it has to be client driven. And so you put your finger on it, mentioning clients. But I think there's another thing one needs to be aware of, that by and large, if you look at all disruptive technologies, and that's what this is, if you look at the classic work in this, for example, by Clayton Christensen, The Innovator's Dilemma was published in, what was it, 1997, looking at disruption across so many different sectors. By and large, the best way to introduce a disruptive technology is to start at a low and unobjectionable level. Because the reality is, if there's lots of heavy hitting litigators sitting in, everyone's pretty comfortable with the high volume, low value cases that often people are representing themselves. Most in the legal fraternity are happy enough for that to go on and to be in some ways systematized. And so you start at that level, but I can tell you what happens. It will prove itself at that level. It will gain traction, and increasingly policymakers, politicians, clients will say, why are you not using it there, there, and there? And the story of disruptive technology is you start simple, and before you know, and it's the notion of task encroachment, stuff that you thought was beyond these systems would be within its capability. But it's this question of, I go back to creating a sense of urgency. And I think it is that there's two ways of looking at this that I say, certainly when I'm advising, because you didn't say in your introduction, there's no reason you should know this, but my day job is advising many of the world's largest law firms and professional firms. And so I say a lot of the way the questions are framed about this are in the wrong way. It's looked as threat rather than opportunity. There is, for example, an opportunity for an international law firm itself to set up some standard platforms for the private resolution of disputes using online dispute resolution techniques. That will be a remarkable disruptive play. And so the tendency for many people when they hear this, understandably when the business is successful, is to analyze this as a threat. But I don't think this is about avoiding competitive disadvantage. For me, certainly the clients I advise say, where are the possibilities out there that give rise to new market opportunities? We can create some new uncontested market space, create it and dominate it. That should be the spirit in which I think law firms move forward. And again, if it's not law firms, and I know you are agonizing across many states about this, but as you liberalize, and liberalize you will, you'll see the big four accounting firms coming in with a very different agenda, with a very different methodology. You'll see the rise of legal tech startup companies. And again, I think big hitting litigators will say, well, we don't rate them. 5 years ago, there were about 200 or 300 of them. There are now about 3,000 or 4,000 of them around the world. Each one of them trying to do to a corner of law what Amazon did to book selling. Most of them will fail, a few of them will succeed and will change our world. I can't prove it, but that's the way the world is going. So I understand you want to hang on as long as possible to the old model, but I think you owe it not just to your pockets, but also to the community to offer greater access to justice and to overhaul a court system, both in the US and the UK, that in our hearts we know is no longer fit for purpose.
Richard, let me shift gears a minute, because we've had a number of questions that all have looked at in varying ways the issue of bias that comes in, everything from bias in the data, biased and corrupt judges, but even more broadly, something we're struggling with in the US right now, racial bias, and even AI's inability to discern as effectively African-American facial features and emotions. address to some degree both the opportunities and the downsides of bias within this technology and how we might look at that going forward.
So this is a fundamental issue in AI research and AI science, and it's being addressed in a way it hasn't, of course, been sorted. The point is this, is that second generation AI system, most of the AI systems we use rely on huge amounts of data. The problem is that a lot of our data is not just errorful, it's actually distasteful, unpleasant, and far worse. And so if systems are relying on data that is biased or worse, then the decisions they produce, the predictions they make, the correlations they identify are likely to perpetuate perpetuate biases. And you're absolutely right. You hear some absolutely awful tales of systems that treat people differently depending of the color of their skin. Now, I have to say, that's the kind of error one can quite easily overcome. These are that kind of, and I know it's widely reported, that kind of case study, to some extent, that doesn't help us with the far more profound problem of unconscious biases that we can't recognize. We can recognize immediately when a system is discriminating in that way. What's more worrying is a system looks credible and credible and appropriate, and yet it's perpetuating these distasteful biases. So I look at this a couple of ways. On the one hand, we now have the most powerful system we've ever had for systems and techniques for detecting bias, because the audit of algorithms, there's two forms of bias, sorry, I should have said. There's bias in those who develop systems, because let's face it, most people who develop systems are males in their 20s and largely, well, they come from particular backgrounds. So very, very limited socioeconomic ethnic groups develop these systems. So you worry about bias, they're often unconscious. And then there's bias in the data. But all the work in AI just now is working. So if you take the example, and this worries a lot of judges around the world, we are now developing tools that can actually help us detect bias in our common law. Because if you think about it, our common law in a way will undoubtedly is a body of data flush with conscious and well, let's say unconscious bias, and a lot of the decisions that are made at one level perpetuate biases at another. So what we're actually developing, and I find this exciting, are tools that can actually identify bias in large bodies of data. And so this seems to me to be liberating and good if we want to look at our immigration judges in this country. And this is controversial. If we want to look at the performance of our immigration judges, we now have the tools to analyze in a far richer way, in a far more nuanced and profound way, the extent to which there's bias in the decisions they're making. So on the one hand, I feel encouraged because this problem is giving rise to tools that can help us identify old difficulties. But the difficulty does remain, that the unknown unknowns and so forth, and we just have to we have to have in place, and there's lots written in this, all sorts of checks and balances, so that in socially critical and financially critical, in economically critical and so forth, other areas, we are not perhaps just simply accepting the predictions, decisions, recommendations, and outcomes of the technology, and this is the field of the ethics of AI. It's a huge field, and we're feeling our way. None of what I've heard or read in this area suggests we should call a halt. We just need to proceed cautiously. There are bigger problems with AI than bias, in my view.
Well, and it does seem that systemically, as we're pushing more diverse groups into STEM, as we're creating robust educational programs, the more we expand the group of programmers and data inputters, the more we will also systemically address that issue. You know, we had an interesting question suggesting, and I'm grafting a little bit of my own thought onto this, about the creation of online dispute systems in the United States. One of the attacks on our right to jury trial has been tucking into those wretched online contracts that we sign for cell phone data or to stream Netflix, a hidden little arbitration clause. Is there an opportunity, though, to embed instead online dispute resolution, whether it is as a arbitration or some other online thing. Is that perhaps an opportunity to get widespread but consumer-facing dispute resolution that still ties into jury trials?
Absolutely. For those of you who are interested, there's the ODR directives in Europe do precisely that, particularly in retail. This was the idea that you embed within the retail sector the first port of call, as it were, as some form of online dispute resolution. And some of the great successes, the poster children for online dispute resolution, eBay most famously mentioned that eBay has 60 million disputes amongst its traders every year, and almost none of them are sorted out by lawyers and courts. They're sorted out by a two-stage online dispute resolution service. And that's actually encouraged many online organizations to try and embed ODR. And there's a whole literature and there's lots of practice, and this is quite advanced, ODR precisely in the way you're suggesting.
Yeah, that's terrific. So because we, of course, are in the business of legal education, how could law schools best collaborate with other fields to start developing this coursework and to try to create a forward-looking group of future lawyers?
One of the great and exciting things about the field of legal technology, in my view, is that it is multidisciplinary. I'm half a lawyer and half a technologist. I'm qualified in both, but it's been one of the treats of my career to be able to mix in legal and technology communities. But it's not just there's so many others you can get involved. So I am heavily involved with the Oxford Internet Institute, and there we have psychologists, economists, philosophers, social scientists, lawyers, as well as technologists working together. And my point is not that you need that wider range of individuals, but just to say it's a great community because it is so mixed. And we tend, just in the nature of things, to know very little about other disciplines, and this really widens your horizons. But I think there's a very clear collaboration between computing departments on the one hand and legal departments on the other. And at Oxford, we've got a course, and it's a great course actually, where essentially our master's level students, about 20 from law and 20 for computing, come together, and they do a course together for a year in the system development, and there's all sorts of things going on. It's great. So I think you need to reach out. There's so many you could reach out to. You could reach out to the psychology department, you can reach out to design, but in the end, I think you want a close relationship with your computing department. So my dream has always been that there are computing, law and computing institutes around the world. You've got a few in the US, actually, more in the US than you got in the UK. It's early days yet, though.
Yeah. Well, as we're coming to the end of our time, I want to thank you so much for what has been just a fascinating lecture. I hope you've looked at the chat for a lot of the hashtag fangirl, hashtag fanguy. So apparently you now have an even bigger following in the US. I encourage all of you, if you have not taken the time to read some of Richard's books, take a start with Tomorrow's Lawyer, his 2017 edition, for some innovative ways to look at this. We appreciate all of you tuning in to the R. Matt Dawson Memorial Lecture Series. We will have more to come. And Professor Susskind, I just can't thank you enough. This was terrific.
The pleasure was mine. Thank you so much.
Absolutely. Thank you, and a good day to all of you.
Richard, thank you.
Great pleasure.